Good morning, members. Happy New Year. This is the first meeting of the Bills Committee on Arbitration Amendment Bill, and we need to elect the chairman. So, very briefly, we need one member to make a nomination and one member to second that. Any nomination? Don't be polite. I nominate Mr. Martin Liao. It's not here. But that's okay. First of all, any seconder? All right, I see that. Mr. Martin Liao? Well, can anyone answer on his behalf whether he's willing to accept the nomination? But, well, I can act on his behalf for the time being, but that may not be desirable. So, Mr. Holden Chow, can you confirm that he would accept the nomination? Oh, here he comes. I'm sure he will agree immediately. We've already made a nomination. Mr. Liao, you understand that you've been nominated? Yes, I know that now. You need to agree to that, yes. All right, that's it. We have a valid nomination. Any other nomination? No? I'll count to 3. 1, 2, 3. Mr. Liao, over to you, please. Do we need to elect a vice chairman? Okay, so let's invite the administration in. So let's move on to the second item of the agenda, meeting with the administration. Maybe I will ask the administration to walk us through the bill first. We have attending this meeting today from the administration, Ms. Li Xiaofang, Senior Assistant Solicitor General, Ms. Maria Tyson, Deputy Director of Intellectual Property from the IPD, and Ms. Emma Wong, Senior Government Counsel, Ms. Jessie Lau, Government Counsel, and Ms. Carol Mock, Solicitor of the Intellectual Property Department. So would Ms. Li please brief us on the bill? Thank you, Chairman. Good morning, members. To further enhance Hong Kong's status as a leading centre for international legal and dispute resolution services and a premier hub for IP trading in APAC region, the government has been reviewing on a regular basis the arbitration system in Hong Kong and made improvements. And in recent years, the government has been making much effort to promote Hong Kong as a premier hub for IP trading in APAC region. The working group has made some recommendations in 2015, including the promotion of arbitration of IPRs in Hong Kong. And as a result of the work of the working group, the government proposes to make amendment to the arbitration ordinance, so as to attract more parties to use Hong Kong as a base of arbitration and to further bolster our status as the hub for IP trading. According to the survey conducted by WIPO in 2013, IP trading has become more and more globalized. These parties to the trade, to the deals, comes from different jurisdictions, and arbitration can provide a single platform for resolving disputes, and we can also rely on the New York Convention to enforce different foreign arbitral awards. And it will be attractive to parties from different jurisdictions. On the other hand, some IP rights, such as registered trademarks and patents, are now being granted or registered by the Intellectual Property Department of the Hong Kong SAR government. And on the validity of registered IP rights, the conventional view is that any disputes should be resolved by the IPD or the Court of Hong Kong. Now, around the world, different jurisdictions have different practices in resolving IP disputes. In the US, Switzerland, or Belgium, the efforts have been made to make it clear that arbitration or IP or disputes involving IPRs can be resolved by arbitration, whereas in some other jurisdictions, these disputes over IP rights may not be resolved by arbitration. At present, the position in Hong Kong is not clear because we do not have the provisions in the law, and there is no authoritative judgment in Hong Kong concerning the arbitrability of IPR disputes. So the law at present is not entirely clear. Although at present we understand that we do have some arbitration of IPR disputes going on in Hong Kong. And based on the recommendations of the working group, the Department of Justice set up in 2015 a working group on arbitrability of the intellectual property rights to look into the issue. If we have substantive provisions to clarify the position, we will be able to attract more parties to come to Hong Kong to resolve disputes over IP rights by arbitration. And we will also gain an edge over other jurisdictions in the APAC region, and will also show the world our commitment to promoting IP rights and dispute resolution services. As for our amendments of the bill contained in the bill, we will base our amendment on the existing arbitration system in Hong Kong, and we're going to add new provisions to clarify our position. And I'd like to point out that there are three features of the arbitration systems in Hong Kong. First, it must be a proceeding agreeable to all parties, and there is also the principle of confidentiality. And third point, there is an inter partes effect. The award will only be final and binding on the parties to the arbitration, but not third parties. And our amendments seek to provide clarification. First, we'd like to clarify that disputes over IPRs may be resolved by arbitration and that it is not contrary to public policy to enforce the awards simply because it involves IPRs, and that it would not be set aside by the court or make it not enforceable by the court. And we've also clarified that in relation to the general principle that the arbitral award would only apply to parties to the arbitration. Last year, we consulted the AGLS panel, that is the panel on administration of justice and legal services of the Legislative Council. The panel indicated support to the introduction of the bill to clarify the legal position in Hong Kong. And we've also consulted the views of the sector, including the IP sector and they also indicated their support or indicated no in principle objection to the proposed amendments. On arbitrability, some consultees also made some comments. We've considered their comments and suitably incorporated some of their comments in our bill. And we'd like to take this opportunity to update the list of contracting parties to the convention called the New York Convention Schedule A. And this list would be regularly updated. And that concludes my presentation. I'll be happy to take questions from members. Anything to add from other government officials? No, we have 2 members waiting to ask questions. Let's start with Mr. Alvin Young, and then Mr. James Toh, and then Mr. Edward Yu. So, Mr. Alvin Young, I have a technical question for the administration. Thank you, Chairman. Now, on the point of arbitral award being binding on the party to the arbitration but not to third parties, I understand that. But my concern is that after making an arbitral award, how can we ensure confidentiality, and then secondary infringement would not be involved? Because if it is established and confirmed that one party has infringed the IP rights, since it's not in the public domain, unlike ordinary cases that come before the court, there would be a judgment which would be in the public domain. I'd like the Department of Justice to respond to that in relation to secondary infringement by third parties without confidentiality, or with the principle of confidentiality. How can you address that issue? Well, let me briefly respond to Mr. Young's question, and then I will see if my colleagues from the IPD would like to add to my answer. The general principle is that the arbitral award is only binding on parties to the arbitration, and this is just a general principle applying to all arbitral awards, not only awards involving IPR disputes. Because it is a dispute between parties to the arbitration. So once an arbitral award is granted, it will only be binding on the parties. But there can be other agreements reached between the parties. If it is viewed that a third party may be involved, then maybe during the arbitral proceedings a third party would be introduced, or that there may be other agreements on confidentiality. Well, let's say we have an IPR owner involved in an arbitral proceeding with a party suspected of infringing the IPR. As other parties are not aware of the arbitral proceedings and are not affected by any award granted under the proceedings, then the IPR owner can pursue liability through other avenues against other possible infringements. As to whether there may be infringement on the part of any other third party, and that's a legal issue.
Anything to add from the IPD? my view is similar to Ms. Lee's, and the awards would only apply to the arbitral parties, and that third parties would not be affected by the award. If the IP owner feels that a third party has infringed upon his rights, they can resort to arbitration or litigation as solutions. I understand the principle of arbitration, but that brings us back to the same issue on the validity of IP rights. Now, this is an ensuing issue. In some jurisdictions, for example, PLC and France, no arbitration is possible. The government explained that the idea is to appeal to more people to carry out arbitration in Hong Kong. But if we handle the issue via arbitration, then we would have issues. For example, third parties would not be binded. So even if I win an arbitration, I have to enter into arbitrations with third, fourth, or fifth parties. So is this really beneficial from a policy perspective? Ms. Lee, thank you very much for the question. Our arbitration mechanism serves to provide an alternative to relevant parties. I do not expect that the parties involved would always resort to arbitration. For instance, if an IP right owner feels that his rights are being infringed upon by multiple parties, they can take the case to the court. For mega cases involving commercial issues and involving multiple parties, for example, a research and development project, and the legal connections might be rather complicated. And in that case, they might want to think about using arbitration as a way out, since multiple jurisdictions are involved, and arbitration provides a singular platform. The issues involved might not be limited to the validity of IP rights. They might raise consequential issues as well. In that case, our laws allow them to carry out arbitration with Hong Kong as the place of arbitration. That way they would have more choices. Next, Mr. James Toh. 5 minutes, please. Chairman, I would like to ask a question. I'd like to read out a statement so you understand my concern. In theory, in some cases, or most cases, I trust the courts. But for arbitration, I'm not so confident. Let me give an example. For example, for an arbitration case involving billions of US dollars, for the Hong Kong courts, no judge can be bribed. So that can be an assumption. Well, if you want to do it, you can try, although it's illegal. And both parties might choose to bribe a certain person, so this is rather dangerous. They are well, of course, this is voluntary. You approach a person and with confidence that he cannot be bribed. So would there be scenarios in the mechanism in which some persons might not act in a voluntary manner? For example, some parties would like to use the IP rights of another owner, but they could not agree on the price. So they would enter an arbitration. If I'm the owner of that IPR, I would not be willing to arbitrate. But would the basis be like this? In the mechanism, there are statutory provisions that the use of a specific right, even if one of the parties do not agree, the arbitration can be enforced. Is there a bottom line on this front? First of all, Mr. To asked about the possible bribery of arbitrators. I would like to point out that in the arbitration law of Hong Kong, the courts can refuse or set aside certain awards for matters involving public policy. For cases of bribe, this would be included. Yes, I understand what you're saying, but I'm just citing the risks. If I do not trust Hong Kong's arbitrators, I would resort to the courts. But in your mechanism, would there be any mandations? If someone fails, would another person be assigned? Would there be any statutory mandations under the law? Ms. Lee, please answer that specific part of the question. There is no mandatory requirement. You can give it some thought later. The bottom line is, well, there would be multiple parties to every dispute. If any of the party does not agree, according to the statute, you would mandate them to arbitrate. If not, well, at least they are willing to take the risk. Well, she already said the answer is no. I would just like to go on record. So if you say no, then I'm fine with it. I'd like to follow up on Mr. Young's question. The court's judgment is made public, but for arbitration, the deal might be done in secret. Or, well, if the parties agree, it might be publicized as well. For a register in Hong Kong, for example, an IP right belongs to a party, and if both parties agree, if they agree not to go to the courts, they want to resort to arbitration, and party B wins. And if B only requires party A to go on trust, and another party C would like to see if there are any infringements. So B would approach party A for a right to secure a right with money. So party A might be concerned. And according to the statutory provisions, there are no requirements on party B to inform party A. If on an arbitrary award, if both parties agree, can you register or enter the judgment? If both parties to an arbitration agree, the award should be included in the register so that everyone would know the result of the arbitration. Is there any downside to this approach? So please offer a brief answer. According to the law, arbitrators can grant different remedies or relief according to the arbitration awards made. For example, they can order one of the arbitration parties to carry out an act. For example, if party A loses, it might be ordered to change the registration in the IPD. It might be asked to transfer the license to party B. If there's no transfer of license, but if it's on trust, what should be done? Under the bill, the arbitral parties would have the freedom to decide what to do. If they do not want any rights of specific performance, well, if arbitrators do not make any orders, well, this is purely a commercial agreement between parties A and B. What I mean is that can you provide for such provisions? Would you allow such provisions? I'm not saying that you must have such provisions. Please wait for the second round. I'd like to add something. In the IPD, we have several registers. We, according to the laws, certain information must be entered into the registers, and they are all applicable and binding on all arbitral parties. So even if both parties agree, we cannot just enter something in our registers. Professor Edward Yu, I have 3 questions. First of all, declaration to make. I have conducted a consultancy study on arbitration in Hong Kong for the SAR government. And for financial professionals, they need more support, and the Financial Dispute Resolution Center can help establish standard documents and provisions. And advice would be given on arbitration and mediation. And on the current amendment exercise, would the government consider introducing a similar support center so that the parties affected can receive preliminary information? And would a table of IP arbitrators be provided so that parties can choose from it? And would certain societies or associations be referred to these persons? And third question, if an IP right has received a patent in Hong Kong or received an R&D grant from the government, if subsequently another foreign IP owner takes out court proceedings against that party for infringement, and if that party wins, an award might be given. But if this original party has abused the fund, and according to the law, no retrospective action would be taken, so how would you deal with such cases? Ms. Lee. On promoting arbitration, we have always promoted our arbitration services to the public, business sectors, and the international community. We have no such support center at the moment, but we do have other legislative proposals which we are working on. We have another bill currently on third-party subventions or arbitration, and it would be introduced into LegCo very soon. Such measures might help the public. For relatively straightforward arbitrations, for example, Hong Kong's International Arbitration Center, they have simple arbitration procedures available.
Now, on the point of whether we have a list of arbitrators for disputes involving IPRs, in fact, the Hong Kong's International Arbitration Center has recently published a list of panel of arbitrators. And there are over 40 arbitrators from over 10 jurisdictions who are capable of being arbitrators. To answer your final question about the binding effect in the arbitration ordinance, and that it is only binding on parties to the arbitral proceedings, well, about the fund you mentioned, I don't have too much knowledge of that, but usually there must be some criteria, eligibility criteria for application, and that depends on the specific criteria mentioned, whether such declaration is necessary. You said that there would not be any follow-up action on criminal liability of the. Can you explain that? I'm not saying that criminal liability will not be pursued. I'm just saying that the arbitral award is of a civil judgment, and the general principle is that it only applies to parties to the proceedings. Dr. Priscilla Leung. Chairman, let me declare first of all that I am an arbitrator in Hong Kong as well as in some other jurisdictions. So I do have some understanding of the arbitral proceedings and the binding effect of arbitral awards. About disputes over IPRs, well, I support the amendment. If the contracting parties agree to take up arbitration, they can also agree to keep it confidential. I'd like to pick up on the point asked by other members. I think specifically they're talking about patents. Well, not only any dispute over IP rights of, say, an invention or other IP rights, because patents involves registration, and you made it clear just now that first of all, it will not per se be registered. The exercise is for resolving disputes, although both parties may agree to disclose the award. But under such circumstances, I'd like to know more about patents. There are parties not yet involved in the dispute, and if the arbitral proceedings have been concluded, because the proceedings might take some time, although not as long as a court case.
你係咪點樣去 rank 啊，或者嗰個
So how can you assess, say, the validity period or the administrative departments involved? Because as far as IPRs are concerned, we're also talking about patents. Second point, there is also a possibility of criminal liability after resolving disputes. If there is sufficient evidence submitted to the relevant departments, prosecution can still be initiated. So I think these matters are separate and they can go in parallel. It is not mutually exclusive. I think my understanding is that this is all about resolving disputes between two parties. Ms. Lee? Well, to answer Dr. Leung's first question, last question, that's true, is about resolving disputes between the two parties. Now, the first question is about patents. we have not proposed any special treatment to patents like other IPRs requiring registration. We need to consider the nature of arbitration, and that any arbitral award would only be binding on the parties concerned. Say if an award is detrimental to one party, and if there is another proceeding with a third party, the outcome may not be the same. Any third party can initiate other proceedings, and the outcome may not be the same. That is why we don't consider it necessary to make the arbitral award public. Apart from these confidential arbitral awards, there could be other confidential agreements involving IPRs, and sometimes legal advice may be sought, and it may not be necessary to make it public either. So all in all, we believe that the confidentiality principle should be upheld. How many other members for the second round? Just James, for the time being. I'm not from the legal sector, but I'd like to raise 2 points from the user's perspective or from the business sector's perspective. Once it comes into effect, we should bear in mind that we'd like to be the leading center for international legal and dispute resolution services and IP trading hub. And in fact, a seminar was held last month in Shanghai, and there were that's a WIPO seminar, and we had some overseas experts from Singapore and from other jurisdictions. I don't know how many lawyers from Hong Kong attended. And we had some specific topics discussed: disputes over IPRs, patents, comparisons between the different jurisdictions, and no expert from Hong Kong attended. Well, you just answered that there is a panel of arbitrators available, but let's say if the bill is passed and if it's acceptable to parties to adopt arbitral proceedings, my first question is whether we have sufficient experts in this regard. And from the user's perspective, I think we're concerned about cost and effectiveness. And from the experience of advanced countries like Singapore, can you give us some ideas? How much cost can be reduced if a party is to go for arbitration instead of civil proceedings, so as to promote arbitration services in Hong Kong? Very briefly, the Hong Kong SAR has been actively promoting our arbitration services to the world, and also legal services. Well, you mentioned the seminar or symposium, and in Hong Kong, say in Myanmar, Cambodia, Thailand, Indonesia, we have been promoting our services to these countries. And in the mainland, we've also made some effort. For example, last year in December, we also attended a major legal forum on the promotion of legal and dispute resolution services. I'll defer to my colleague to take your question. Apart from arrangements made by the Department of Justice, we also jointly organize workshops on mediation to promote mediation as a dispute resolution service. We also maintain regular liaison with the sector. For example, we organize IP training classes for the personnel in the sector, and we also have other promotion efforts jointly made with the Department of Justice, such as workshops and seminars. And may I also supplement on the figures, and this is based on the survey conducted by WIPO in 2013 in relation to resolving disputes over R&D IP rights. And in general, if it is resolved through legal proceedings, it would take 3 to 5 years. Whereas if it's resolved through arbitration, it takes about 7 months for simple cases or 23 months for more complex cases. So there is a difference in terms of the time needed. And on legal costs, if court proceedings are taken out, then that's about 475,000 to 850,000 US dollars. Whereas if it's done by arbitration, it's about 66,000 US dollars, including the fees for the arbitrator. I also have one question. I'm speaking for the first round. If there are no other members, then I'll go. Let me first declare that I'm also an arbitrator from the Hong Kong Bars Association, and I fully respect the fact that the arbitral award should be confidential. And it is by mutual agreement. But from the perspective of commercial principles, some third parties may be very closely related to the IPRs concerned. For example, transfer of technology, there may be some agreement, there may be licensing, and in some jurisdictions there are compulsory licenses for some patents. So if the kind of IPR is registered, then we can rely on the registration system. But like Mr. James Toll said, if both parties reach an agreement to exercise their right by way of trust, then if a third party would like to apply for a license or compulsory license for technology transfer, then they would not have any idea of the arbitral proceedings. I wonder if there is an impact on their commercial operation, especially when you're talking about IP trading center. You may have a lot of cases of transfer of or assignment of IPRs, and that may generate a lot of problems in the business world. Would you consider adopting a registration system like the land registry? You can choose not to register if you want to keep it confidential, but at the same time you have the right to register the award. Because at present you do not have the right to register the other interests, such as trust, on the register maintained by the IPD.
So would you allow them the extra choice of making a registration, and the benefit is that you can tell the world that you are interested, whether or not you want to engage in a transfer or obtaining a license. You would know where the real right is vested. Would you offer this option such that after the arbitration, regardless of the result, they can choose to be registered? Thank you very much. As I said, for registrations under the IPD, they are all applicable to third parties. For those in our registers, there's a binding effect on all third parties. We would only accept decisions by the IPD or the courts which are binding to third parties. For other judgments such as arbitrary awards, very often they are based on evidence provided by both parties, and third parties cannot take part in the arbitration. This is different from court orders or decisions of the registry, which allow third-party participation. So how would they be affected by the arbitrary awards, or would they be relevant at all? And in some cases, there might be it might be misleading, and the situation might be different. For arbitrary awards and the relevant documents and evidence, the third parties might not be in the know. So if we are to enter judgment in terms of the award, it might be misleading to third parties. I understand what you mean. And for the lands registry, not all memorials entered into decisions of the court. For any agreements, for example, mortgage agreements, and they would be entered into the land registry's record upon consensus by both parties. It doesn't mean that these memorials or agreements would not be legally challenged. There's no conclusive legal ground because not all of them are ruled or judged by the courts. A choice is already available. It's only that the choice is not published in the register. Both parties might not have to opt for confidentiality. They might not have to publish it. But if they are approached by a third party who wants to do a deal, if the arbitrary parties agree, they can inform the third party of the situation. Perhaps I would wait for the second round. Ms. Eunice Yong. I have a simple question. In paragraph 7 of the executive summary, it's explained whether an arbitrary award can be enforced, and the validity and other issues, and these are all factual disputes. For IPR disputes, they are mostly factual in nature. So if we are to lodge an appeal for arbitration, we understand that appeals are very difficult, and it's possible in only less than 5% of the cases, and they must be due to deficiencies with the arbitrators before an appeal can be lodged. And since most IPR disputes are factual in nature, would this discourage people from taking action? And if I see issues, I might not opt for arbitration. I might opt for the courts. So this way, even less people would opt for arbitration in dealing with such cases. Ms. Lee. Under our arbitration mechanism, certain provisions are available to allow for parties to join the proceedings or arbitration proceedings, and this might be due to appeals, if possible, on legal grounds. Of course, this must be agreed on by both parties, so they can agree on this if necessary. As for whether people would be discouraged to use arbitration, I think the key of the amendment is to offer more choices for the parties. I don't think with an extra option they would be discouraged from using this approach anyway. So I can only lodge an appeal on legal grounds. And but the fact is, if I see any problems, I would not opt for arbitration at all. So I think this option is not necessary. Well, at least we have an extra option. Mr. Holden Chow. Thank you. In the summary prepared by LegCo, I'd like to turn your attention to paragraph 13. It says, according to Part 10 of the Arbitration Ordinance, and an arbitral award is enforceable in the same manner as a judgment of the court of first instance that has the same effect, and if leave is granted, the court may enter judgment in terms of the award. In this regard, there might be a question as to whether a declaratory award involving an IPR right might have erga omnes effects if a judgment in terms of the award is entered under Part 10 of the Ordinance. And to put matters beyond doubt, Section 103H is added to clarify that Section 73(1) of the Ordinance, which confines the finality and binding effect of an arbitral award to the parties and any person claiming through or under any of the parties only. So in this entire paragraph, it points out and the arbitrary award would be similar to judgment of the court of first instance, and it can be the judgment can be entered into. And Section 103H would be added to confine the finality and binding effect of an arbitral award to the party. So I'd like to talk about this erga omnes effect. So would the rights and obligations be owed towards all? For Section 73 of the Ordinance, the validity applies to the arbitral parties. For Section 103H, we merely want to clarify that when the courts enforce the awards, they would grant a judgment to enforce the arbitrary awards in order to avoid misunderstandings on whether the court judgment would induce an erga omnes effect on the award. We just want to clarify that it would not be the case. The court would uphold the original award, and that the award would only apply to the arbitral parties. So this is just a technical clarification. In the arbitration ordinance, the principle is for awards to be binding only to the arbitral parties. So this is just a clarification. In paragraph 13, you cited an example. If an arbitral award is enforceable under Part 10 of the Ordinance, and the arbitral court might deem a certain grant invalid, or the tribunal, if deems the trademark invalid, if this scenario arises and parties beyond the arbitral parties might be affected, the record might be absent and other parties might be affected. So this is a good example, and I'd like to look into that. We will look at it in this manner. The arbitrary awards only apply to the arbitral parties. If the arbitrator says a trademark is invalid, according to the principle of the ordinance, it's only invalid to parties to the arbitration. It doesn't mean that the trademark would be invalid to other parties. If the court only repeats what the arbitration said in saying that the trademark is invalid, then people might misunderstand that the trademark is invalid. For this example, if a trademark is deemed invalid, then it's only deemed invalid to the arbitral parties instead of deeming a registered trademark as invalid in the register. We are only pinpointing declaratory awards made by the court. Since we do not want any misunderstandings such that such declaratory awards would deem the trademark invalid for all. Mr. Paul Chair, followed by Dr. Junius Ho. Members asked a number of questions, and we talked about requirements of the Lands Tribunal. Of course, if we are able to provide an extra option for people to resolve IPR disputes, but apparently on one hand we want to make it more appealing, but on the other we want to limit its effects. As Mr. Chow suggested, the conflict is that on one hand we want to provide an option, but on the other, should people resort to litigation or arbitration if third-party interests are concerned, if registration of patents and trademarks are challenged, and you would be creating trouble for yourself if you go for arbitration, because you would be going around in circles and ultimately you would have to go to the courts. So in terms of policy, apparently you are providing an option for parties, but in reality this is not of much help to them. So we are back to the issue of limitations of arbitration. So apparently you want to align with other jurisdictions, but it doesn't really help much. This is a policy question. Apart from this new option, are you trying to save resources for the courts of Hong Kong? You might think that litigations might take a long time at the courts, and the judges have to spend a lot of time dealing with these cases. Would this be a policy consideration?
Well, on the point of policy, we have a series of measures. We do not only have one measure. We hope through a series of measures we can enhance and improve our arbitration system. As to whether the parties to the arbitration would really take the route of arbitration, that depends on the circumstances of the case. And indeed, not every case may rely on or may be resolved by arbitration. But the fact is, for IP trading, at the moment, different jurisdictions have different collaborative efforts across jurisdictions involving knowledge transfer or cross-licensing of IPRs. And in these cases, it may be attractive if there is a single platform of arbitration for them to resolve disputes. It may also be attractive on the front of enforceability, because we have the New York Convention with over 150 state parties. So I think a streamlined set of procedures can be provided for enforcing the award. Well, in short, I think if it's about whether there is any right infringement, then it's a simpler issue. If it is on the point of arbitrability, then it is not advisable. Can I take it that way? In fact, in responding to Mr. James Toe's question, I already said that both either party has the right to apply for relief. For example, if the patent is ruled invalid, then the party can seek the court's direction to enforce a specific performance on a party, say, to go to the trademarks registry to remove that patent, or the registry of patents to remove the patent. I can also instigate court proceedings to declare that a patent is invalid. It may be a point of controversy. It could be a dispute over licensing, for example. And say there may be a buyer who wishes to buy a basket of IPRs, and the buyer may question the validity of some of the IPRs, and instead of taking the route of court proceedings, the buyer may wish to use arbitration or to check with the IPD. Mr. Junius Ho, I'd like to ask Ms. Lee some questions because I'm not familiar with IPRs and patents, but my understanding is that, first of all, for arbitration, if there is any dispute, any party can resolve disputes by arbitration. So I think arbitration ordinance applies to a very wide scope of things. But as far as IPRs, we'd like to enhance our status as the IP trading hub. So we're having this bill for copyright disputes, IPR disputes. Now they can be resolved by arbitration. But in fact, there's a clause in the arbitration ordinance. Any disputes, including disputes over IPR, can be resolved by arbitration. So if that is the case, why do we need 11A? For Part 11A, 103D, Section 103D, it says, that IPR dispute is capable of settlement by arbitration between parties to the IPR dispute, and if an agreement is agreed, then well, so on and so forth. Perhaps that's my understanding of Section 103D. So it says here, if there is an agreement, so it seems to suggest that something like the Pope is Catholic. So that means the parties need to instigate arbitration proceedings before invoking 103D, and then in 103D you'd like to clarify the ambiguities. It can give jurisdiction to decide the IPR dispute. Say, for example, if the IPR dispute, well, I mean, there may be a minor dispute over IPR, but for 103D 4B, it seems that some gray areas can be covered, even if it's not some specific issue. Now, my point is it necessary for both parties to expressly agree to adopt arbitration? That's the existing position. In the future, if we have 103D, if things remain unclear, then it can give jurisdiction, and then it can also the party can also rely on 103D. A brief response. Ms. Lee. Well, under the existing arbitration ordinance, what kind of dispute can be resolved by arbitration? Section 19 of the arbitration ordinance gives effect to Article 7.1 of the UNCITRAL Model Law, Option 1. It sets out the kind of disputes that can be resolved by arbitration, and that is, there is a defined legal relationship between the parties, whether it's by way of contract. So we do have the definitions ready. Using this general definition, we do believe that there are many IPR disputes which can be resolved by arbitration. So my question, briefly, is this. Well, originally, some disputes can only be resolved by consent, but now with 103D 4B, because of the implication, even without consent, one can take another avenue apart from the conventional court proceedings, and that there would be a lot of fuss. The answer is no. Very briefly, Chairman, if I may, another question, please. In 70, it says 103D6, subject to 103D6, if there is a subject which is the subject of the court proceedings, the court may grant emergency relief, and then the court of first instance or the arbitral tribunal can also decide on the remedy and relief. I don't understand that, because if we choose arbitration, there is an exclusive jurisdiction of arbitration. So we have an arbitration clause, but if you apply for a stay of proceedings, taking up court proceedings, and at the same time it is arbitration based, and if there's an arbitral award given, then it seems it would seem to make the court proceedings invalid, and that the arbitral award would be followed. But now in 70, it says that in the future the court can make such ruling, and then the arbitration tribunal can follow the court's order. I don't understand. Is it that when there is arbitration, we can do away with court proceedings, and then if there is an arbitral award, which should follow? It seems that the court would follow the arbitral award rather than the other way round. I don't quite understand this part. When in fact Section 70 does not relate to this point. When the court of first instance grants remedy or relief, or when the arbitral tribunal grants relief or remedy, it will have the same effect of a remedy or relief granted by a court of law. Alright, understood. So that's all for first round. Second round, Mr. James Toh and Ms. Paul Chair. Chairman, in principle, I agree with the bill, but I want to further clarify matters. It seems that the arbitration ordinance does not carry provisions to expressly provide that some disputes over IPRs. Well, let me rephrase my question. Is there any provision in the existing arbitration ordinance that provides that certain disputes cannot be settled by arbitration? We understand that some IPRs may not be resolved by arbitration, some PIs as well, but there isn't any provision to clarify that. Mr. Chair has rightly pointed out the issue. Now, there are grounds not to enforce the arbitral award. Say, if the award is in respect of a matter which is not capable of settlement by arbitration under the law of Hong Kong, and this is, for example, a matter related to a criminal matter, or if public law rights are involved, for an administrative department to exercise public power, that is, for example, where the immigration department deciding on whether certain individuals should be allowed to enter the territory, and and by convention, some IPRs, such as patents, have to be registered with the IPD. And there is a question on these registered IPRs, whether any disputes over these registered IPRs can be resolved by arbitration. So there is an ambiguity at the moment because it's not expressly provided in the law, and also on the public policy ground. There is a question on whether it can be resolved by arbitration, and we want to clarify all these matters. So the basic principle is that both parties must agree to use arbitration. But apart from that, there are also other considerations, such as public policy ground, etc. And this amendment bill seeks to clarify these ambiguities.
On one hand, the arbitral parties would have to opt for arbitration, and on the other, the subject matter must be arbitrable. Of course, there were no judgments on whether they could be arbitrated or not, and there was nothing on record in that any arbitration or arbitrary awards was set aside or refused. But I think this is just guesswork, and hopefully you can do better. There was no such case as we understand. There were judgments by the courts in other jurisdictions in the past. Dr. Junius Ho. I'd like to follow up on what Paul said. In the past, before we had this proposal, in a dispute between parties A and B involving IP rights, both parties involved an arbitrator, and some matters have been resolved. But since it was relevant to public interest, for example, the registration of certain trademarks with the government, but that there is a dispute between parties A and B, but the trademark was approved by the government and it was registered with the IPD, and now parties A and B involves party C, who is an arbitrator, and there is an arbitral award, and now parties A and B do not want the arbitrary award given by party C be enforced, and they want to enter judgment for the award, and they would not accept this judgment. So it's the purpose of Part 11A to relax the rules so that the IPD would enter judgment on the decision or agreement between parties A and B. So is that the main effects of the amendment exercise, or is it the other way around? I'm a bit confused. Ms. Lee, the principle of arbitration is that the arbitrary awards would only apply to parties to the proceeding, but not third parties. Because of this reason, since the awards are confidential in nature, they would not be entered into public registers at all. They only apply to both parties, but not other third parties. But whereas information or judgments in our registers are binding to all, so that means party C's award would not be entered into your books. Well, I'm even more confused. I thought that's the original intention. Mr. Dennis Kwok, Chairman, if both parties enter into an arbitration, if a certain registered trademark or patent, if they lose the case, the registration of the registered trademark or patent might not reflect the arbitrary award made. So for the public, when they look at the registers of registered trademarks and patents, the registers might not reflect who actually owned the IP rights. The ownership might be lost after the award is made. So how would you balance the public's right to know and the confidentiality of the agreement? After an arbitration, the parties do not have to change the ownership of the registrations at the relevant registries. Is that the correct understanding? Yes, this is correct. So how would we strike a balance? Even though arbitrations are confidential in nature, they are a form of agreement which requires consent from both parties. for the awards, they have no direct effect on third parties. But legally speaking, the arbitrator might rule that one of the parties, for example, the patent owner, would lose, and the parties would still retain legal rights, even if the arbitrator says your patent is valid. Some third parties might feel that they should not be valid, and they might take out legal action.
Allowing the parties, through an arbitration agreement with the confidentiality clause, to create possibly a false impression that certain patents still belong to a certain individual, when that individual may have already lost the right to that patent through the arbitration. So there will be a false or inaccurate record on the public registration system regarding the ownership of that patent. So how are you going to address that concern?
其實我諗呢個呢
On the arbitration and the court's judgment, these are two different concepts, so we have to make a distinguishment. For arbitrations, if both parties agree to involve a third party to assess the status of the patent, they might agree that they would act based on the third party's award. Legally speaking, and this is different from deeming a patent invalid from a legal perspective. I understand this point, but from a public policy perspective, especially fair competition, if a person has lost or ruled to not be in ownership of a patent, and if he is still the owner of the patent, do you find this fair? We did consider this issue. The nature of arbitration is that it would only apply to the arbitral parties, but not third parties. The owner of the patent still retains legal rights against third parties. This would not jeopardize fair competition. From a public interest perspective, the patent register might not reflect the actual ownership of patents. So as a member of the public, should I trust them or not? Or should I trust the register or not? Even if an award is made to deem a patent invalid, if it's taken to court, they might have a different judgment. And because of that, we cannot publish the judgment just because there are deficiencies. Litigation can be taken out, and eventually if both parties decide to settle. Well, Chairman, I have a quick question. Did you consult the Competition Commission on whether this practice is feasible? We did consult our internal advisor on competition law. Did you consult the Competition Commission? We would look at this, and we can provide additional information. Mr. Kwok, I'm also concerned with what you said. Simply speaking, if parties A and B enter into a an arbitration if party A is the owner and party B challenges his ownership. The actual ownership is not reflected in the register for third parties such as you and me. I can challenge party A or B if we want. So my concern is that from a public policy perspective, such practice might not be fair. I'm just concerned whether this would affect commercial operations, for example, tech transfer, compulsory licenses, etc. I would allow other members to speak. Ms. Alvin Young. Based on our discussion so far, I'm not sure whether my suggestion would be unprofessional. Can we learn from the land's registry? Can we have appendices or something like that? And my opinion is that you do not have to include the actual results of the arbitration. You just have to introduce appendices that an arbitration has been carried out. And this way, the public would at least have limited understanding without knowing the actual contents of the arbitration, and this would safeguard the confidentiality for both parties. If the arbitrary parties want to keep it confidential or act on trust, at least they should be given an extra option, just like the lands registry. And that way you would inform everyone that you have an interest in it. And this would benefit enforceability. But apparently this has not been considered. Would you consider that? Chairman, the IPD has said repeatedly that there are limitations on what can be added in the appendices or remarks. Many members have raised this point today, so can any amendments be made? Since the purpose of the amendment bill is to attract more people to carry arbitration in Hong Kong, this would help public understanding. If we take a leaf from the Land Registry's book, for the Lands Registry, they have to include the entire result of the judgment. But in Hong Kong, if we just add a remark so that people knows that arbitration has been made, then the public can find out for themselves. And this way, we would not jeopardize the confidentiality. By way of a trust, this remark can be added. So you don't have to specify the beneficiary. Yes, they have heard you. Mr. Holden Chow, Chairman. We talked about paragraph 13 of the LegCo brief. Can we do something like section 13? When an arbitral award is made, can it be enforceable in the same manner as a judgment of the CFI that has the same effect? We asked whether the binding effects would have an erga omnes effect, and even if the judgment is entered, a number of members asked about the confidentiality issue. Can you follow what you said in paragraph 13? that means you must enter the judgment after a decision is made. And the judgment or award would only apply to the parties involved, and this is very clear in paragraph 13. So would you adopt the approach in paragraph 13?
Ms. Lee, I will go back and consider members' suggestions, but I would like to reiterate why we consider confidentiality very important, because the arbitration system in Hong Kong is that when we tabled the bill in 2009, we added the confidentiality clause to emphasize that confidentiality is an important element in our arbitration system, which makes the system attractive, and that the arbitral award is only binding on parties to the arbitral proceedings. Other third parties are not bound by the award. And when we studied the issue, we also considered Mr. Dennis Kwok's point, whether it is unfair to third parties. Well, an arbitral award is very different from a court judgment. When both parties decide to resolve disputes by arbitration, they can also decide to act in accordance with the arbitral award. That is, for both parties to find a third party to give binding legal opinion. So in that sense, it is different from a court judgment, which has the erga omnes effect. And the final arbitral award may not be the same as the court judgment. So, if it is suggested that it would be unfair to a third party if the arbitral award says that the IPR is invalid, we don't agree, because the arbitral award itself is different from a court judgment. It's sort of private in nature. For day-to-day business dealings, we have a lot of confidential agreements, confidential dealings, and very often experts may be engaged on matters of IPRs. And if arbitral awards are required to be made public, then does it mean that all these private agreements have to be made public as well, on the ground of unfairness to the third party? On the other hand, when the court decides not to enforce the arbitral award, it has the power to do so on the ground of fairness. And if it is contrary to the competition ordinance, if it contravenes the competition ordinance, then relief may be sought from the court not to enforce the arbitral award on this ground. I understand that, because if it's against public interest or contrary to public policy, the award can be not enforced. In other words, it can be made public. Well, that is to say, the arbitral award will not be recognized or acknowledged. Next, Mr. Paul Chair. Chairman, I think we should go back to the basic point, whether IPRs is in itself contrary to competition, whether it's a kind of private property. Many colleagues here find it difficult to grasp. All these suggestions about registration, making it public, we want more protection, that's all. The IPR does not seek to protect public interests. Otherwise, public power should not be exercised to protect private interests. Therefore, in a way, two parties can decide to settle the case by court proceedings. If the dispute is not settled, your rights or interests may be undermined. And you may not want to affect your registration and the binding effect of your registration around the world. I think Hong Kong has taken steps towards protecting private property interests, then protecting public interests. I think we have already gone that way. We need to acknowledge that, and then we can understand what we're talking about. You want to provide more tools, more options for international consortia, for IPR owners to go for arbitration instead of court proceedings. Because to put it more frankly, they don't want their interests in the international arena to be affected. Now, another point I'd like to ask is this. I hope you can clarify this. Chairman just now asked a question, and also other members asked the question. Well, I don't think it's a question at all on the point of ownership. Be it a trademark or patent, once registered, if you ask the person making the registration, what is it for, the person would say that you should go for the real owner. Well, I don't even know what question I want to ask, because I think it's all about giving more choices to international consortia. I don't think this can be dealt with at this Bills Committee anyway. That is, whether you will work towards undermining competition or excessively protecting IPR, I don't think that is the case. So I think that we don't need to spend much time on transparency or civil rights. To respond, the arbitration system is in place for private disputes to be resolved. So it's private in nature, and it's questionable whether the public should know anything about it. And the nature, it's private in nature. It is for parties to resolve private disputes, and that applies to other commercial deals. My understanding on IP trading is that the general view around the world is that IP trading is not really it's not really contrary to or undermining competition. And competition is an issue that does not only apply to IPRs but also to other sectors like retail and other business transactions. What we understand is that arbitration means engaging a third party to resolve private disputes. For various reasons, IPR disputes, parties to the IPR disputes may not want to resolve the dispute by arbitration. But sometimes we see disputes involving an IPR that involves different jurisdictions and different parties. Mr. Junius Ho, the mic is not on. I thought I could get a clear answer from my last question, but I'm not. I'm even more confused. Providing another choice for parties to resolve IPR-related disputes in Hong Kong by arbitration, I fully accept that. I just want to know whether this will be complete. Using Mr. Dennis Kwok's example, if Party A, owner of the IPR, is challenged by Party B, and if Party B succeeds, the fact is that Party A's rights have been registered, and if after the proceedings Party B succeeds, then in Part 11A, Section 103H, in my view, suggests that the award can be, or judgment can be entered in relation to the arbitral award, only that it must be done in accordance with Sections 84, 87, 92, 98A under Part 10. Well, if the arbitral award is clear, if the patent is ruled to belong to, one of the parties, and yet it is still kept confidential, then what's the point of having the proceedings? What's the point of using arbitration? Why don't I go for court judgment and injunction for enforcing specific performance for Party A to remove the patent to prevent further further rights infringement? Now, the objective of arbitration is to save time and cost, and the arbitral award will also be binding on both parties. But now with Part 11A, you're extending the effect, because it says parties other than, say, Party A or Party B. Section 103H in Part 11A says that if there is an arbitral award granted by Party C, the director of IP would accept the arbitral award without the need to seek a court order. But now you say that it is against the confidentiality principle and that the third party right will be affected. And what is meant by that? If I successfully challenge Party A, I think this is for protecting the third parties, exactly. That's my understanding. Ms. Lee, when you talked about the fact that it cannot be registered, I think that it is against notion. So, Ms. Lee, because 103H states that the arbitral award can be entered into the judgment, I'm not asking for it to be binding, but if Party C grants an arbitral award and Party A is bound by the award and Party B now owns the right and that it is registered, then it is in the public domain. I'm not concerned about the arbitration right. I think that she's suggesting that the arbitral award can be entered, but I think that the IPD will only accept an assignment of IPR instead of simply entering into judgment. You can choose whether to do it or not. I think that's the point. Say if the arbitral award states that Party B has successfully challenged Party A, then Party B can seek for an assignment of IPR from Party A, and then Party B can register the IPR. But you can also choose to do it by trust instead, and that is Mr. Ho's question. For court proceedings, a court order would be made to direct the IPD to make the assignment.
That's the difference. Ms. Lee? For Section 103H, it might be a bit different from what we have been discussing. We talked about arbitrary awards and whether or not they would be entered with the IPD, and we said the answer is no, because we must maintain confidentiality. If the losing arbitrary party does not want to enforce the award, and that the other party might request the courts to enforce the award. So we are talking about the judgment entered in the courts. Section 103H is not very clear. For that, we can wait for the clause-by-clause examination. Mrs. Dennis Clark. And we have 7 members with a legal background, and we all see the same problem. Of course, our views might not be the same, but I think from a fair competition perspective, we should consult the Competition Commission to see what they say. I am aware that we have fair competition lawyers in the DOJ, but the Competition Commission is the body responsible, so we should ask for a written response or views from the CC. I agree with Dr. Ho. If this is the case, what's the point of arbitration? At the end, I still have to resort to the courts. So why didn't I go to the courts at the first place? Of course, there are benefits to arbitration. It might be faster or cheaper. But from a public interest standpoint, if the public registers cannot reflect the actual or real owners of the patents, there might be a lot of issues in the future. As for the Competition Commission, Ms. Lee said she would consider inviting them for comments. And as Dr. Ho and yourself suggested, I think there are benefits to arbitration for certain issues such as tech transfer, licensing arrangements, etc. Some clients might not want the details to be disclosed in the courts. The speaker is not coming through. They should judge whether or not the judgment should be entered, but the IPD cannot say that they do not allow the judgment to be entered. No, that's not the case. The IPD would accept the entering of the judgment, but there must be a transfer agreement. A transfer might be mandated by the arbitrary awards, but the parties can choose whether or not to follow. Any other questions? If not, Mr. Kwok talked about consultation. I don't think an open hearing is needed, but I'd like to know the Competition Commission's views on whether this practice is proper from a fair competition perspective. So can the DOJ consider that? So perhaps you can work with the committee secretariat on how to proceed with this matter. Any other questions? The date of the next meeting would be informed by the secretariat later. Based on our discussions before the next meeting, would we receive a response from the DOJ on whether or not and how they would consult the Competition Commission. The Secretariat would work with the DOJ on that. Meeting is adjourned. Thank you.